Hi, today I am here with another question, that what happens to the property of a Hindu woman who dies intestate? So, a Hindu woman, if she dies intestate, now we have to understand the definition of intestate. It means that a person who dies without making any will. So, now if a Hindu woman, she has a property of her own and she dies without making any will, so what happens to that property? So, in order to understand the property related issue, we have to understand what the property means. So, a property may be a movable property or an immovable property. The property, she might have got it via an inheritance or by a partition, or in lieu of any maintenance or arrear of maintenance, or via any gift from any relative or anyone else, or she might have made it through her own skill, or she has purchased it, or may have got it in any other manner. So these include the list of the property, and she might have acquired it from any of these sources. So another important thing the definition includes is STRIDHAN. The property which a Hindu woman acquires is her STRIDHAN. So she is now the absolute owner of her own property, and she is not a limited owner as that was there prior to the Hindu Succession Act 1956. So now here we have to understand, now we come back to what happens to her property that will be devolved into the list of the legal heirs that is given in under section 15 of the Hindu Succession Act 1956. So under this section, it has been mentioned that the first legal heir will be her children, her son, daughter, and this includes the children of the predeceased son and the daughter and her husband. So these are the people who will acquire the first place as a legal heir, and then the second place is the legal heir of the husband. Then the legal heir will be the mother and the father. Fourthly will be the legal heir of the father, and fifthly will be the legal heir of the mother. So this is the list. According to this list, if the first criteria is being fulfilled and she has her children, so obviously it will be devolved into them and her husband. But in case if she doesn't have any children, or she doesn't have any children of the predeceased children, or she doesn't have her husband, then what will happen to the property? So here we are going to discuss a case which has been discussed which has been dealt by the Honorable Supreme Court in the year 2009, and it is Om Prakash versus Radhacharan. And in this case, what happened that Devi Narayani, she was a young widow who actually became widow only after within 3 months of her marriage. Then she had to come back to her. She was thrown out of her matrimonial home, and then later she had to come back to her parents. And then after that she studied well, and then she actually acquired huge amount. She has left a huge amount in her bank. Her provident funds were there, and then she died at the age of 42. Later on, her mother, she applied for the succession certificate in order to claim her property. Simultaneously, the legal heir from the side of her husband, her husband's sister's son, he had also applied for a succession certificate. Now there was a dilemma before the court whether to go with the sentiments or the emotions, or whether to follow the criteria which is given under the section 15(1) of Hindu Succession Act 1956. Now the Honorable Court has suggested this case to be a very hard case. Sorry, the term that was used is hard case. So the Honorable Court had to decide as per the law of the land, and the legal heir of the husband had has acquired the property of the deceased Narayani Devi. So from this case, we have learnt that the discrimination regarding woman, or we may say that the area of the gray, there is a gray area regarding the self-acquired property of a woman. From this case, we understand neither the property was from her mother or not from her father. She did not inherit the property from them. So it was not that the property had to revert back to her mother's legal heir or the father's legal heir, but what had to no, as there was no any other legal heir, so the property had to go to the legal heir of the husband. In that case, the matrimonial house had thrown her out, and they did not take proper care in that regard, and neither they had any hand in her development nor in her educational purposes. But later on, they came and claimed. So it is now upon a Hindu woman to first decide that if she has her self-acquired property, whether she wants to, she should decide herself that upon whom her property should go or who should be able to claim her property. So she has to decide on her own. And in case if a property is acquired from the side of the husband, or if it's a property acquired from the father-in-law's side, and if the woman is dying intestate without having any other legal heir, then the property goes back to the legal heir of the father-in-law or the husband. So this is what the section says, that the property actually gets reverted back to the actual owner's legal heir. If it has come from the mother's side or from the father's side of the woman dying intestate, or from the in-law side, then the property reverts back in case if she does not have any children or no any other legal heir. So in this case, now a woman has to actually decide that whether she wants to die without making any will, or upon whom she wants to give the legacy of carrying her property. So in my suggestion, I feel like a woman of today's should make a will before she thinks that she is biologically weak, or she is going to succumb to her natural death. So in that case, she should properly think of the future of her own property. Thank you for watching.